Hey everybody, I'm Ken Lammers. For those of you who don't know me, for those of you who do know me, I'm still Ken Lammers, and this is the 12th or 13th year I've done one of these. Well, actually, it's more like the 11th or 10th since we took 2 years off for COVID, a nice vacation. But here we go again, and let's jump into it. Same rules as normal. The Mike Abbott rule applies. You can't ask questions while I'm going through it because I've got a lot to cram through 2 hours. But at the end, I will be happy to pretend I know any answers to any questions you have. So, let's start. As always, we're going to start with the United States Constitution. That's what we always do first. And here we go. The Fourth Amendment, bags. Now, we all remember Gantt, right? Gantt said you cannot search somebody or search somebody's car just because you arrested them. That overturned a pretty long-standing precedent that had been around and we'd all been relying on, which didn't make the most sense in the world, but it was something that was there. It was a hardline rule. Well, that went away. You can't search cars, and that's a totally different case, just because you arrested somebody. Now, the Fourth Circuit, this is a Fourth Circuit case, mind you. I don't think this is law the way it is in Virginia currently, but I think this is this is the way it's trending across the nation. We may see this come to the Supreme Court, and it gives you all who are defense attorneys something to argue, although I think Virginia law will stand against you. In the Fourth Circuit in this, U.S. against Davis, Davis was down on the ground, face down, hands cuffed behind him, and while he was arrested, and then they went and searched his bag. And the Fourth Circuit said, no, you can't do that. He was totally under control. There was no way he was accessing that bag. And in doing that, they do distinguish a couple of their older cases and say, look, if the guy's under arrest, but he's up walking around on his feet, his hands are cuffed in front of him, that sort of thing, he can still reach the bag, yes, then the search is valid. If the guy is down, if he's secured and far from the bag, whether he's secured and how far he is from the bag, those are relevant factors. This guy is totally secured. You took the bag away from him. He wasn't accessing it. But if you don't handcuff the person, if you don't keep them secured, then you can search the bag. Courts, gotta love courts trying to make officers make their job more dangerous. Okay, residents. The residents. This is Lange against California, and in Lange there was a California trooper, and eluding a police officer there is just a misdemeanor, unlike in Virginia where it's a felony. And guy did the typical thing where they go and flip off the officer, make a lot of noise, not just keep moving, right? The officer follows him all the way home, lights him up, he doesn't pull over, right? So there's a misdemeanor crime, not pulling over. And the officer follows him to his home, goes into his home, and arrests him, gives him a DUI, the whole 9 yards. And the Supreme Court of the United States says, well, you can follow somebody into a house for a felony, right? You can't do it for a misdemeanor unless there are exigent circumstances, basically unless there are exigent circumstances. So, if you don't have a warrant, if they don't have an arrest warrant, they can't follow somebody into a house on a misdemeanor, even if they've seen the crime occur. Of course, there's exigent circumstances. If an injured occupant, imminent injury, destruction of evidence is imminent, and the person could escape. Those are the only reasons you can go in if you've already got probable cause, unless you got that arrest warrant. So that's a fairly significant change in the way we've all thought the way the law works. So only go in with felonies. Community caretaker, or the Mike Abbott argument. This Cadiglia against Strom here. The Supreme Court is like, community caretaker? What community caretaker? We never said you could do this community caretaker thing. what are you doing, right? And what happened in this case was the officers took a guy away for a mental evaluation or for a mental lockup. I don't know exactly what was going on there, but he was gone. They realized he's got a bunch of firearms in the house. Rather than going off and getting a search warrant or going off and getting a red flag order like you could in Virginia, and they just go into the house and take the firearms. And this ends up in court, and somebody, like one of us lawyers, stands up and goes, "Oh crud, I've got to find some argument that the officers didn't do it wrong. Let's say that, community caretaker, because they were trying to, make the world safer, a better place for themselves and the community, for everybody, right?" Well, the court says, no, that's not good. And they're like, the fact that we've said that that police do these civic tasks doesn't mean that they just get a pass if they're doing some sort of civic task. They still have to follow the Constitution. So they don't, they basically, there's a part in the opinion, it's been a while since I've read it, but a part in the opinion it says, what is community caretaker? We never said there was a community caretaker exception. You people have been making law without us, and there are other exceptions, but none of this community caretaker stuff. And so we all just went ahead and ignored them and keep using the community caretaker anyway as shorthand for all sorts of other reasons that an officer would be in a place. McCarthy against Commonwealth, and this is later in the same year from our Court of Appeals. And in McCarthy, the court says, look, community caretaker does not apply to homes or motel rooms, any place that's kind of a residence, right? Doesn't apply. So, oh, thank you. Sorry, whatever. Okay, so you're saying thank you for somebody saying Gesundheit or God bless. Doesn't apply in homes or motel rooms. They do say there's still the emergency aid exception for homes, hotel rooms, right? There would be exigent circumstances too, but not here. Emergency aid exception, somebody needs aid, duh. Somebody's in the house screaming, "Help me, I've fallen and I can't get up." Limited to exigency, you can only go in to handle the situation, and officers can do a cursory sweep of the location while they're doing this. Make sure nobody's going to jump out, and it's not an ambush. Nobody's going to jump out and stab them in the back while they're trying to deal with somebody who's hurt. But no community caretaker. Cars. Mitchell against Commonwealth. This is from our Court of Appeals. Poor Herbie here has seen better days. And what the Court of Appeals said is, look, he runs the plates, the guy's suspended who owns it, he then goes and pulls it over, and it's a different person driving, and things proceed from there, which is what happened in this case. It's reasonable to assume the guy who owns the car is the guy who's driving the car. And the Court of Appeals says that's just fine. I think that's just common sense. We've all been dealing with that, working with it under that assumption for a long time. Okay, shooting and seizure. This is interesting case all around. Application of physical force. Once they put force on somebody, even if it doesn't subdue the person, they're seized, right? They can escape the seizure, but they're seized once the officer puts force on them. They do say, an arrest is physical force or submission, right? And a fleeing person is seized while they're shot. And I don't remember all the facts about this case, but I do remember that, the guy's running away, he gets shot, he keeps running, so he is seized when that bullet hits him. He escaped seizure when he keeps moving, but he's seized when that bullet hits him. All around interesting. This could have some play with Virginia law, which has really, there's a number of cases that are really about you're not seized until you submit, right? Well, if there's been a use of force in any way, shape, or form, they're seized, right? So even if they don't submit. So that's something to keep in mind. The right to confront. Cortez Rivas against Commonwealth. Translator on the scene is not a witness. So you've got somebody that doesn't speak English. You are desperate enough to call me in to try to use my Arabic. Ana biyatkalam mahum. I talk to him for a bit, get the answers back and forth, but I don't do anything, right? All I do is use the language. And then goes to trial, and you get a competent interpreter who actually speaks both languages really well, and you want to call me as you're saying that what was said at the scene can't come in because the translator, I must be there to testify. This is the court saying, Supreme Court of Virginia saying, no, all the translator is doing is using words back and forth. Unless the translator added something to the situation, then you can call them for that. You can't call them just because they were the translator. Logan against Commonwealth. This is about return of service on I think it was a protective order, and the deputy who did it wasn't in the courtroom when it came to trial, and therefore the defense's argument is, look, you don't have anybody here to prove that this guy was actually served his protective order. And the court goes, well, I mean, it's right here on the paper, right? And he goes, no. Without that deputy there to testify that that he actually signed it, you haven't got that proof. And this is the Supreme Court saying, no, we're not going to buy that argument. Return of service isn't testimony. The primary purpose test says it's got to be testimony for them to be necessary constitutionally. It's not testimony. All it is an administrative thing where the deputy signs off and says, yes, they took the paper, right? I imagine if you really wanted to, as a defense attorney, you didn't think your client really did get it, you could call the deputy yourself, but I suspect that wouldn't have helped the poor guy in this case. Mr. Logan probably wouldn't have been helped with that. So then we get to Pulley against Commonwealth. Again, a primary purpose test as to jail calls. And in this case, Pulley says, whoa, they're taping me because they want to use it in court. And the Court of Appeals says, yeah, that's not the test. The test is, why were you making the call? And unless they're making the call with the intent of using it in court somehow, no. It's not the primary purpose test. It's call your aunt, call your uncle, to conspire with your buddies, to do whatever else, right? It is not to be testimonial. So it can come in. Hemphill against New York. New York had, this is from the Supreme Court of the United States, New York had this interesting rule that hearsay could come in if the officer believed that there had been significant evidence that misled the jury. I mean, if the judge believed there was significant evidence that misled the jury. And the Supreme Court of the United States goes, no, that's not the way it works. The judge doesn't get to decide whether the jury's been misled. That's a factual decision for the jury to make. The judge is just there to make sure that procedure and Constitution is followed. And the Constitution here doesn't allow, unconfronted hearsay in. So they kick it. Kick it back. Cruel and unusual punishment. This is about minors, right? Let me see if I can get off here to the side a little bit. Minors getting life in prison. Now, we all know it's not legal, constitutional, under the current interpretation of the Constitution for minors to get a death sentence. It's also not legal for them to just constitutional for them to automatically get a life sentence. So there's been this push to say that the judge had to explain his finding that kept the kid in prison for the rest of his life. and he had to make a specific finding of permanent incorrigibility, right? This is the Supreme Court saying no. All that's required is a discretionary sentencing scheme. So if there's nothing that requires the kid to be put in prison for the rest of his life, if the judge has discretion, then it's all good. Don't have to find permanent incorrigibility. Don't have to explain their sentencing decision at all. Okay, due process under the 14th Amendment. Competency decision. Now this Clark case was one where the defense attorney wanted to get a competency eval for his client. Judge just wouldn't even consider it. And the defense attorney's going, look, he's not so cuckoo gone. Cuckoo for Cocoa Puffs. I can't work with him. And the judge's like, nope, it looks good to me, we're going, right? Now I'm sure there are more factors to that. Did the judge think this was some sort of continuance game? Is this an attorney whom the judge thinks applies for, a competency evaluation on every single case, right? Something like that, where the judge is like, yeah, but that's not in the case in its explanation. So it goes up, and the Court of Appeals gives us kind of a generic list of what you would look at to see if competency evaluation is needed. Irrational behavior, history of irrational behavior or mental illness, their demeanor at trial, which I guess means their demeanor at hearings before trial, really, and prior medical opinions that have found them incompetent. It's an abuse of discretion for the judge just to refuse to consider the defense counsel's representations, right? Defense counsel is saying, look, Judge, my client is cuckoo for Cocoa Puffs. I need a competency evaluation. There's supposed to be a significant amount of weight that attaches to that. Now, I would suspect that if you're a judge and you don't do a competency evaluation where the defense attorney says that, you really need to have some sort of reason on the record. Otherwise, you're probably going to get overturned. In the era of mandated appeals, you're probably going to get overturned. Appeals of right, not mandated. So, Ray against Commonwealth is a kind of an interesting case. It's a drug task force that's using a confidential informant, and the confidential informant is going to go after a particular person, and they're like, well, who is this guy you're going after, you're going to buy from? It's like, I don't know, his name's Bobo, right? And they're like, Bobo? You got a last name or anything? No, just Bobo. So they go through their files and they find a guy named Bobo Jones, right? And they show this confidential informant Bobo Jones' picture beforehand, goes, that Bobo. And he goes, yeah, that's Bobo. Well, okay, then they pull it off, they do the buy, I guess it's Ray, Bobo Ray, not Bobo Jones. They do the buy, and it goes to court, and the defense attorney goes, wait, they didn't do a lineup, they just showed my guy one picture. And the Court of Appeals answer to that is, before anything happened, and as a way of identifying who they were going after, not as a way to identify an unknown party who had committed a crime. We're all good. No due process violation. So let's look at evidence. The experts. Kilpatrick, pedophilia characteristics. He wanted to put on an expert that would say he did not have pedophilia characteristics. He was convicted of going after a girl who was under 15, and his defense was, she didn't look under 15 when I propositioned her, did this. She's smoking, she's drinking, she's wearing a dress that, holy cow, that sort of thing, right? That's his defense, and he loses. But they didn't let him put up his expert to talk about pedophilia characteristics and how he didn't have them. And this is the Court of Appeals saying they should have let him have that witness. It didn't determine the final outcome, right? It wasn't a final decision. Just going to be expert testimony on a certain point, which was very important. He looked at this girl and didn't think she was 15, right? So that goes in. McDaniel against Commonwealth. Now this is blood splatter evidence we're talking about here. It was based on photos. And defense objects, says that the expert was never at the scene, he didn't see it in real life, etc., etc. And the Court of Appeal says, well, that's fine, but that doesn't exclude it. That just means that it goes to weight of evidence. And if you can argue to the jury that the fact that he used a photograph instead of going to the scene should be dispositive as to a factual matter, go for it. But it is not an exclusionary thing. They go on further to say you have to challenge photos when they're introduced, not when the expert is testifying using them. So when the detective introduces the photographs, 3 witnesses earlier, that's when you got to object. Try to object to them when the expert is using them. You've already lost your time. Can't do it then. Co-conspirators. Play against Commonwealth. Co-conspirator statement can come in if it's in the course of or furtherance of the conspiracy. And, before it can come in, you have to make that prima facie case of the conspiracy. And to make that prima facie case, you can't bootstrap, the prosecutor can't bootstrap, he's got to make it without using the statements. So, the prosecutor can't use the statements of the co-defendant, the co-conspirator, to make the case that there's a conspiracy with a co-conspirator, which most of the time is how you prove there's a conspiracy with a co-defender, co-conspirator. It's what they say. I guess you have to prove it through actions. Makes life a little more interesting. Pre-trial stuff and procedure. We're in procedure now, and we're at pre-trial stuff. Bailey against Commonwealth. This is continuances. The Court of Appeals keeps saying this, doing this year after year after year. There's, every couple of years, there's at least one case that does this. And this might be something we all want to keep an eye on, because I suspect our judges, at least, are unhappy with the number of continuances we have right now, at least in Wise. So look out for continuance requests starting to flop. Continuance request. This guy hires, he hires the attorney 2 days before trial. We've all seen this. It's a fairly standard, oh crap, how can I have my case tried on Wednesday? And then, of course, there were witnesses who weren't subpoenaed. And so they want a continuance. The defense attorney walks in, understandably going, Judge, this is a case that's going to take me at least 2 weeks or a month to get up to speed on. And Judge is like, nope, it's going in 2 days, one way or the other. So that's that, and the Court of Appeals says that's fine, right? Now, and they did say in this case there was 4 months notice. So hiring an attorney at the last second and not having subpoenaed your witnesses, life sucks for you because you didn't do what you were supposed to do, right? And it is all totally within the court's discretion as to whether or not they turn down that continuance. There's no abuse of discretion there whatsoever. Turning down the last second new attorney continuance. Hammer against Commonwealth. This is one of those cases where they think they've got it worked out. The defense attorney or the prosecutor says up to the judge, well, they're going to plead on counts 3, 4, and 5, so we're going to null pros counts 1 and 2. And the judge says, okay, it's null pros. And then the defendant gets up there and goes, I ain't pleading to nothing. And the prosecutor says, well, we pull back our null pros then. And the judge says, that's fine. And they go on and try him on all the stuff. He objects, of course, and Hammer gets to the Court of Appeals and says, look, it was null pros. the way the game is played is once they null pros it, it's null pros. There is no case to bring back, and the Supreme Court or the Court of Appeals says, no, it doesn't work that way. It's got to be written down before it's actually, it made an order before it actually exists, and even then, the trial court's got 21 days to rescind that order before it's permanent. So, I gotta say, this is a little iffy, I think. And it would only count with null process or dismissals without prejudice. Couldn't do this with dismissed with prejudice. So, I think you're absolutely stuck with a dismissed with prejudice. But there's that. Just remember that null process, I worried for years when I had judges say, I'm null processing this, and then they went to do the plea agreement. I was like, have to go back and re-indict if they reneged. Don't now. You can just get the judge to say, okay, that null process disappears into thin air. Pre-trial bail. Davis against Commonwealth. Now, we all know that generally trial judges do not have to explain their opinions. And usually, it's fairly smart of them not to. As much as we would all like to know why the judge decided the sky is green instead of blue, it's generally in their interest not to give the basis, because then when it goes to the Court of Appeals has all sorts of room to operate in, right? But on bond, on bail here decisions, they have a duty to articulate the basis of their bail decision. This, I think, is mainly because if it's appealed to the Court of Appeals, they don't want to have to figure it out. They want to be told, right? So that's there, and they do state specifically in Davis, the length of pretrial incarceration is not relevant. If your guy's been in for 6 months, that doesn't have a bit to do with whether he's a danger to the community himself or he's going to flee, right? That's just the amount of time he's been in pretrial. So I'm sure that all your defense attorneys are just absolutely going to stop arguing that to the judge. Yeah. All right. So Palmer against Commonwealth. This is kind of an amazing, interesting case here. Palmer asks for a bond. He gets turned down for it, and then he files his papers with the Court of Appeals, right? Says, wants that reviewed. I don't know if Palmer screwed it up and actually did it as an actual petition or what. I mean, I've found that the Court of Appeals is pretty quick about these things when you file it. It's motion work. It's not an actual appeal. It's motion work. And I found the Court of Appeals pretty quick on it. But whatever reason, Palmer's case doesn't get done from the Court of Appeals until after his case is done in the trial court. He's found guilty, right, and gets his sentence. Well, Palmer's attorney soldiers on and takes it all, goes to the Court of Appeals and does, fights about that bond status. And the Court of Appeals goes, there's no bond to argue about anymore. His case is over. Pretrial bond status is done. And they dismiss it on that ground. So basically it's moot. There is no point. That is one obstinate attorney, though. Gotta give him some credit for that. Closed circuit. The infinite and ongoing battles as to whether closed circuit can be used, whether it violates the right to confront, whether or not, what you can use it for and everything. Well, this was actually decided on procedural matters, not on the confrontation clause. But Ruff against Commonwealth, they had video set up so the defendant could watch as some child victim was in the other room. His attorney was in the other room with the child victim, and he claimed, he's like, look, I can't really interact with my attorney there. I can't, I'm sitting there on the phone trying to talk to him and that. It doesn't work. And the Court of Appeals says, yes, it does. As long as you have that phone where you can communicate with your attorney while your attorney is in the room with the child victim, you're good. that phone provides you adequate access to your attorney. Okay, affirmative defenses. This is kind of the year of affirmative defenses. They did 2 or 3 things on this year. Pinedo against Commonwealth. This is your claim of right the affirmative defense in a robbery. If it is your property and you go to take it back from somebody using a firearm or whatever force or threat, right? You do that, well, you can't steal your own property, so there is a claim of right affirmative defense. It was my property. When I stuck the gun in his face and made him give it back to me, I didn't do anything illegal. Now that can be actually your property or something you have a good faith belief is your property, right? So, no robbery. Even if the good faith belief is mistaken. So that's there. But, the Court of Appeals says this does not apply if you're dealing with contraband, money from the sale of contraband, or any fruits of the crimes. So, you're trying to get your meth back, you don't get a claim of right defense. You're trying to get the money that some guy should have paid you for your meth, you don't get a claim of right defense, right? You try to get the TV that you bought with the money that you got from selling meth. I think it's a little more touchy, but fruits of the crime, I think it's arguable not. So, I think those are the parameters of that claim of right defense. Myers against Commonwealth goes through, kind of lays out what standards are for various different types of affirmative defense. It lays out the general rule is this. The Commonwealth attorney doesn't have to prove absence. And, affirmative defenses are generally, things that we can't prove didn't happen, right? Or, again, hard to prove absence. They're also affirmative defense if it's something that would be in the defense's knowledge without the prosecutor being able to scramble up that knowledge, right? But what you have to provide is more than a scintilla of evidence, generally. More than a scintilla of evidence. I've never seen an actual definition of exactly what scintilla is, but for an affirmative defense, you have to provide more than it, and then the prosecution has to overcome that to win your case, right? There are exceptions to this. For an accommodation, if you're running an accommodation, you have to prove by a preponderance of the evidence that your client was accommodating that drug deal, not actually a principal in not actually the guy who's benefiting from it, right? And for insanity, the standard is the precise satisfaction of the jury. So if you're going to try to prove that your client was insane at the time of the offense, you have to work to the satisfaction of the jury. Interesting enough. So, next affirmative defense, drugs. Thompson against Commonwealth. Here the Court of Appeals just lays it out. They're like, look, if it's about drugs, it's under the title with drugs or the chapter with drugs in it. The Commonwealth attorney does not have to prove negatives. You didn't have it for this. You didn't do this. You're not that, right? The Commonwealth attorney doesn't have to prove those. That's on you. Basically, you as defense attorney have to prove exceptions, excuses, provisos, that's a little broad, and exemptions, right? And it even gets more specific and says, look, if this language is in it, unless or shall not include anything after those words, defense attorney has to prove, right? So, basically any time it's like, yes, I dealt the drugs, but it's on you, right? But I was allowed, but I was forced, but I, whatever. That's on you to prove. So, go for it. Sentencing. This also could have gone under probation. I didn't have any other decisions for probation this year, so it got here. That, by the way, is Isaac Parker, the hanging judge, kind of a famous guy from out in the old Western days. Hung a bunch of people that were outlaws out in the Old West. Okay, sentencing. Hill against Commonwealth here. This case drives me nuts. It simplifies some things and just goes off the rails in other places because we can't possibly do anything having to do with probation and the period of suspension for the sentence and get it 100% right and make it make sense. Just can't do it. I think the Court of Appeals is constitutionally incapable of doing this. Okay, so here's the general rule that we will all be dealing with in court. If the judge sets a condition, sets your client out with 3 more years of probation or 2 years of probation and doesn't say anything about the period of suspension, the period of suspension goes just as long as the probation does, right? Now, to be clear here, what the actual ruling of the case is, if the judge sets a condition for a period of time, then the period of suspension goes with that condition. That initially comes out of a case which discussed good behavior, because good behavior was a condition, and you couldn't possibly have a condition if there wasn't suspended time. Makes sense, right? With certain parameters around it. And probation follows that same rule. Probation is a condition of the period of suspension, and therefore it is, if it says 3 years probation, then the period of suspension follows it. Caveats, things to watch out for. If the probation office extends probation, that would not, goes to the judge, say we want probation extended, or just doesn't end probation, that would not count. The period of suspension should not extend past there, right? Also, there is a limit on the period of suspension. The period of suspension can only go for the maximum amount of time that a full sentence would have been. So, if it's a Class 6 felony, 5 years, right? The period of suspension can only go 5 years. If probation extends past that, well, there's a hard stop there for the period of suspension. So, you got to watch that too. So, if you've got somebody who's been on, probation for the last 15 years, and we all know, I think most of those guys have been cleaned out. The judges went after that a while back, but I think most of those guys have been cleaned out. But their maximum sentence was 10 years. If they're beyond that, measured from the date of the first offense, first conviction, and they're on probation, they ain't on probation, right? The period of suspension is gone. Then, that's all fine, right? That works out, and that makes sense. And then they go off the friggin' rails. In dicta, the court says, you can't be given time after probation ends. Well, that's clearly wrong, right? I mean, you can only be given time during the period of suspension. The length of probation doesn't really affect that, except that when it carries the period of suspension with it. And then they say basically that probation and the period of suspension are the same thing. I think the words they use are de facto the same thing. Well, de facto they're not. And they are de jure very clearly not, as I found 3 cases within 5 minutes of reading that said, no, not just no, heck no, right? Probation is a condition of the period of suspension. I get that the statutes are screwy in this area and need clarification, need cleaning up, but that's just really wrong. But there's beautiful language in there for those of you who are defense attorneys that say when probation ends, the period of suspension ends. When probation ends, they cannot get any further sentence. It's also really goofy about stuff in there. They talk about how some places break it up as to active probation, non-active probation, right? Like we do here. Your supervised probation, unsupervised probation. As I have said a million times, everybody here has heard me say it, there's no such thing as unsupervised probation. Dang, my cat just tapped me. Well, you're in. Go for it, cat. No? Okay. There's no such thing as unsupervised probation. You have the period of suspension, you have probation period, and unsupervised probation, they seem to say in here, you are actually on probation then still. You're just not on probation. That's garbage. There is no such thing in the statute. But that's for future days, and I don't get to make those arguments anymore. That's on y'all defense attorneys out there. Have fun with it. But basically, though, remember the rule. If the probation, oops, sorry. I get these buttons too close together. Basically, remember the rule. Probation carries with it a period of suspension. So if the probation is extended, and it's not extended beyond the period where the statutes require a period of suspension to end, it's all good. And post-trial. The things we got going on here. We got Bailey against Commonwealth. If you file some sort of motion within the 21 days, Rule 1.1 says at 21 days that there is nothing that the trial court can do anymore because that's the end of it, right? That final order is final at day 21. So you file something and on day 18, you win your motion in front of the judge and the judge says, I'm going to overturn the entire thing, it's all done, and I'm not even going to let the prosecutor come back and retry the case. But he didn't sign that until day 23. Bailey says, life sucks for you because he's got to sign that order. That written order got to be in place within the 21 days. Right? The problem that Bailey's got, and it's something you all defense attorneys need to keep in mind, is Tailor against Commonwealth, which says pretty much exactly the opposite from the state courts, which is all, they give a kind of a weak rationale for this, but it pretty much violates the interpanel accord doctrine. But, Tailor stands for the fact that the order is the statement of the court, and all you're getting with that piece of paper is a memorialization of that order. So, have fun. There's where your arguments can be for those of you who are out there doing defense work and fighting with that 21 days. Ritchie against Commonwealth. This is a case where Ritchie is, the judge says, okay, I'm going to take it under advisement for a period of 6 months to be dismissed. If no further problems, you will be on conditions as long as you don't smoke pot. Something like that, right? And goes to the, 4 or 5 months in, Ritchie, of course, smokes pot, or whatever he did that violates that one condition. One condition that the JDR court left. He comes back into court and says, no, we're past 21 days, you can't do anything. And this one's the one where the Court of Appeals says, well, look, there's that 16.1242, and that allows the court to keep total jurisdiction over a case or to keep jurisdiction over one part of a case. In this case, it kept jurisdiction over one part of the case, and when Ritchie didn't do what that one condition was, ta-da, he gets to come back and get sentenced. Okay, well, let's take our 15-minute breaks here, folks. I think we're about there. And come back at 3:10. We're going to pretend that we've had the 15-minute break and I've scrambled around doing whatever I've got to do. And here we go. Okay, everybody sit down. Sit, you, down in the back. And y'all who've not been to our CLEs think I'm joking there. I've had to do that before. Okay, so let's start with actually substantive crimes and what case law we've got on these this year. Okay, we've got Barnett against Commonwealth. Whoops, shoot, buttons are too close. We've got Barnett against Commonwealth. Wounding by mob, right? This is your whole group of people charges in, and you can't prove who did what to whom, but you just know you got three guards at the museum who are badly injured, right? That's wounding by mob. To convict somebody in the mob, you don't have to prove that they encouraged it, that they aided in it, that they countenanced what was actually done, or that they agreed to the nature or manner of the injury, right? All that has to be proven for a conviction is that they were a member of the mob, that they shared the mob's common interest, the mob caused the bodily injury, and the mob acted with malicious or unlawful intent to maim or kill. So if you're part of that crowd, the crowd does something, you're stuck with it. This is the old anti-Klan statutes, which they've been repurposing over the last 10 years or so. You know, clans or citizen committees or whatever get together, they go do something really stupid, and then one of the guys will say, oh, I didn't mean for that to happen. Life sucks. You're still guilty because you were part of the crowd that did that. Okay. Then we get over here, Everhart against Commonwealth. This is a child cruelty case. It's about corporal punishment. Court starts off by saying corporal punishment is allowed. And then it says something that's really kind of scary. It is under an ever-changing standard. Let me say that again. Ever-changing standard. So the fact that I think that spanking a kid on the rump, you know, and mom slapping a kid who says a rude word, you know, obscenity of some sort, is a fairly appropriate punishment. And if half this room disagrees with me, ever-changing standard. Oh, wow. Now, factors to be considered, whether or not the punishment is too much. Age, size, or conduct of the child. Nature of the misconduct. The instrument used. Yeah, if you use your hand as opposed to the belt that my mom and dad kept in the junk drawer. And if there were any marks or wounds, right? And you know, we've all seen this anywhere from a little bit of redness on the rump to really serious bad bruising. And at the end, the court concludes, just because you were engaged in corporal punishment doesn't mean you didn't also have an invalid criminal act going on. Again, ever-changing standard. That's not a standard. That's a guess. Okay, White against Commonwealth. This is something that came from the Fourth Circuit. So, and yes, this is a lady robbing a bank dressed entirely in pink. I'm actually kind of impressed. Now, White against Commonwealth, this came from the Fourth Circuit down to the Supreme Court of Virginia. I'm not sure how separate sovereignties the Fourth Circuit can make the Supreme Court of Virginia do an opinion, but apparently they can. They basically said, okay, for sentencing guideline purposes, federally, a robbery has to be a violent act. Is a robbery a violent act in Virginia, you idiots, since you haven't written it into a statute yet? And our Supreme Court goes, why, no! It doesn't have to be a violent act. The common law, which we still follow for robbery, does use violent act or threat of violent act for robbery, but threat of force, but also under the common law, if you threaten to accuse somebody of sodomy to get money from them or some other item from them, that was a robbery. We've never taken that out of our thing because backwards common law folks that we are, haven't written a statute to do away with that. And so that's there, and it's a nonviolent act, so it's a nonviolent crime. Now, they do clarify, it still has to be, currently, you could still rob somebody this way, but it has to be something that is currently illegal still. So, I run up to somebody and I say, you give me $10, or I'm going to tell everybody in the world that you have sex with minors in an evil sodomite way, right? And they give me $10, I've just committed a robbery, right? Interesting. I never really thought calling somebody a sodomite could get you in prison. Or threatening to call them a sodomite get you in prison. Sex crimes. There's a little bit of bad stuff here. Haba against Commonwealth. Haba is having sex with a woman, and they're having a sexual relationship, and he wants pictures, and he wants them badly. She's refusing. She's like, no way. Look, she explains she's from Saudi Arabia, and if it's proven she's had premarital sex, she can get killed in Saudi Arabia for that, right? Well, he ain't taking no for an answer. And he, one day when they're together, she's sitting there, he wants to take pictures. She's covering herself with a blanket. He rips the blanket off of her and takes pictures. All right. Court says, no. Unlawful creation of an image. Just because you're having sex with her does not do away with her expectation of privacy as to photographs of her person. You're guilty. Go to prison. Johnson against Commonwealth. This is about unlawful filming. Johnson is filming women when he's having sex with them, or at least the particular woman in this case, not telling her, and apparently sharing it. Although I don't think they proved that at trial from the way the Court of Appeals dealt with it. His defense is, whoa, look, she's having sex with me at my place. And the court's like, yeah, which is an agreement to have sex with you at your place, not a waiver of her privacy rights as to filming. She didn't agree to that. And then the court goes on further, again, go to jail, do not collect $200, do not pass go. Again, the court does say it doesn't require sharing. You just do the illegal filming, you're on the hook. More sex crimes. This was a court screw up, and I don't remember which court, but under 18.2, 374.3, soliciting a minor with a communication system. Although I'm pretty sure it wasn't using a Sidekick 2. This was my first cell phone, by the way, folks, one of these. They were cool at the time. But soliciting a minor via a communication system. The guy gets charged, Mackey gets charged with soliciting somebody who's under 15. We get to the end of the trial, the judge says, well, I don't think they really proved she was under 15, so I'm going to change it to subsection D, 15 to 18. That they proved that he had solicited somebody between 15 to 18. Defense attorney objects. I object, Your Honor, that's not allowed. And the judge says, yeah, it's lesser included, so we're good. Go to the court, and then during sentencing, the judge says something to the effect of, look, I could have, under my own inherent powers, looked at the facts and then re-indicted this personally, or recharged this personally under the proper statute and convicted, but it's a lesser included, so I didn't have to do that. I didn't do that. And by the way, that's a power that judges have. We put a case in front of them. They don't think we proved the right thing. They can just say, okay, well, I'm going to recharge them under this, convict them of that, and I'm going to dump your other charge, right? They can do that. Don't ask me the exact process. I'd have to look it up. But it's out there. But this goes to the Court of Appeals. The Court of Appeals says, no, Subsection D is not a lesser included of subsection C. Subsection D and C both have different elements. Subsection D, the child has to be between 15 and 18. Subsection C, they have to be under 15. Those are clearly different elements, right? They then go on and say, and yes, we realize the judge said I could have done it this other way, but the judge didn't do it that other way. And if he did, we'd be addressing something different than this. So, you don't get to salvage it by saying the judge said he could have done something. So, go back to court. And appeal 1. More sex crimes. I'm sure we'll all be shocked to know that for aggravated sexual battery or other sex crimes, you cannot consent while you're asleep. So don't try to wake up your partner happy. Massey against Commonwealth again. This is Massey's different one. Okay, this is basically a pimp, right? Massey, he gets this homeless drug addict woman. He moves her into his house. He takes her money, what little money she has, and when she gets money from working like part-time jobs, and he keeps her supplied with drugs, and eventually forces her to have sex with a third party, and it was both sodomy and regular sex, and he ends up in court, and the court says, yeah, you force somebody to have sex with a third party, you're as guilty of rape and everything as everybody else. Pool against Commonwealth. Gotta say, we all know the spousal rape exception. There was a spousal rape exception in the statute that was taken out a while back. And Pool goes, well, but it wasn't taken out of the case law. And the spousal rape exception was in the case law well before this statute, still part of the common law. But gotta give this, whoever the attorney for Pool is, that's creative, and you gotta have stones in a Me Too era to make that argument and not worry about your front window getting broken and your car getting keyed, right? But he makes it, and the Court of Appeals goes, after a discussion on the difference between English common law rape of spouse and Virginia common law rape of spouse, which was interesting, they go, spousal rape is not legal. It was a law. They took it out of the law. It's not legal. Goodness sake. Drug crimes. Allison against Commonwealth. Paraphernalia, right? This is needles and syringes. We all know what we're dealing with here. And basically the Court of Appeals says there has to be a reasonable indication that the needle and syringe is there for illegal drug use. Found with illegal drugs, has illegal drugs in it, has residue of illegal drugs, etc., etc., whatever other reason. And the, just can't be, you got needles. Those could be for your diabetes or something like that, right? Commonwealth against Richard. This is a case where I think a guy and a gal are going to go buy a car from another guy and they're going to pay with drugs. Well, that obviously goes bad for them because they're in court. They get to court and they're charged with conspiracy. And Richard says, whoa. Wharton's rule is very clear here. Wharton's rule, for those of you who don't know, is that a buyer and a seller can't be charged for conspiracy, right? They just have an interaction. It's done. They're done. They're gone, right? So Wharton's rule says you can't charge them with conspiracy, and that's what Richard says. Wow, wait, I just sold some drugs to a guy for a car. You can't charge him with conspiracy on that. And the Supreme Court says, there's that third-party exception. If you're with somebody and the two of you are dealing with another person, Well, you're conspiring with the other person you're there with. So yes, you're guilty. Wharton's rule doesn't save you. Drugs, again, pulling against Commonwealth. How much or what is probative to your intent to deal, right? Obviously, quantity, packaging. If it's packaged in big blocks, unusual amounts of cash on you. Probably the denomination's cash too, but they didn't say that. Drug paraphernalia or equipment. The ubiquitous scales, right? Or stuff for use of it, whatever. And they do say, in the end, they say quantity alone can be enough. So if this is your client's truck, I think we can make that case on quantity alone. Prosecutors can make that case on quantity alone. Smaller amounts, there might be more to debate. Okay, elder financial abuse. Tomlin against Commonwealth. Tomlin and her mother are living alone together. Tomlin's in her 50s and not really, from what I can understand about the case, doesn't seem like she's really in good shape to take care of herself. And her mother's like in her 80s or 90s, right? And is not in shape to take care of herself at all, is wearing Depends and all that stuff. They keep turning down government aid. The government, social services keeps coming and saying, look, let us help you. Let us somebody come over and help out. Let us do some stuff. And they keep turning it down. At least Tomlin does. And finally comes, one day they come over to do a check and they find the mother on the ground. She's obviously been there for a few days. She's covered in feces. And they take the mom away and they find some physical issues and all that. And of course she's covered with feces. But the mother is unable to understand what they're talking about when they start talking about what's wrong with her, right? She doesn't get she's just not there. She doesn't get that she's covered with feces. She doesn't get she's got bed sores. She doesn't get she's got other issues, right? She's not able to understand that. Well, meantime, Tomlin has been spending mom's check that's coming in, right? Basically living off mom's check. She's spending mom's check up to that point, and afterwards she continues to spend mom's check. And they charge her with financial exploitation of an incapacitated person. Well, she's found guilty. It gets to the Court of Appeals, and the argument is whether or not they've shown that the mother didn't have capacity to let her have the money, didn't understand what was going on, and the Court of Appeals says, look, just because she didn't understand her medical condition doesn't mean she didn't understand her monetary condition. That's iffy. I mean, that's really iffy, but that's where they stand. I get that, I might not understand that I have cancer, or if I've got cancer, that I'm not treating it right, I might not understand that or be obstinate about it. But whether or not I do a financial transaction with somebody else is not dealt with by that, right? Doesn't apply to that. I'm still able to do financial transactions. I understand it in that manner, but in this case, I would say that the mental condition was so bad that that's a hard case to make. But the Court of Appeals made it, so there you are. Theft of property, by the way, that right there is Speaker Pelosi's house. Somebody didn't want to pay rent anymore, and so they did all this to her property, or this is about destruction of property actually. They did all this to her garage and left a pig's head, and I imagine that's some sort of blood, on the ground in front of it. Nice folks. Okay, Glass against Commonwealth. This is about this felony destruction of property. And how it's about the restitution amount, really, because they were fighting about how much the restitution is going to be. Now, you understand, remember, the difference between restitution in a larceny, and there's difference in restitution and destruction of property. In larceny, it is fair market value of the item at that time. So you've got a really unique car, but nobody else really is going to want that thing, right? So your car's actual value, say, is $1,000. But so that's if it's stolen, you're owed $1,000. If it's destroyed, right, destruction of it, and it costs you $10,000 to get it either repaired or replaced because it's so rare, that's your restitution on destruction of property. Okay, now they go further into that, fair market value for repairing or replacing. And they come up with possibly the silliest, I don't want to say dumb, but the silliest definition for fair market value I think I've seen. Fair market value is the price property will bring when offered to sale by a seller who desires but doesn't have to sell it, not obligated to sell it, and bought by a buyer under no necessity of purchasing. So, Paul Johnson back there wants to sell his, sell his Mustang, right? He didn't really need to sell it, and I don't really desire to buy it. So the fair market value is what we would come to as an agreement. That makes no, he wants to sell it, and he wants to sell it, but he didn't really need to sell it. So he sets the price at like $2,000. I am not really terribly interested in buying, don't have any need to buy that thing. So he wants to sell, say he wants to sell his truck, or his Mustang, right? He wants to sell it. He doesn't really need to sell it. He just wants to sell it. And I don't really need to buy it. He wants to sell, he decides he wants to sell his car, right? But he didn't really need to sell it. He just wants to sell his Mustang. I don't have any need to buy that car. How the heck do you get a fair market value out of that? That's one of the goofiest definitions. I sometimes wonder if our Court of Appeals understands the free market concept. Weapons. Okay, Myers against Commonwealth. You remember a few years back they put that secured container exception in to concealed weapons statutes, the concealed weapons statutes. This was because, this didn't happen here too much, but I can tell you it happened around Richmond a lot when I was doing defense work back in the Stone Ages. Guy would go out to work in some area of Richmond that was a bad area. He'd take a pistol with him. While he was there, he kept it sitting on the chair next to him, seat next to him, right, or wherever he went, he had it in open view. And then he's driving home. He stops at the 7-Eleven. He locks it in the glove compartment because he's not going to carry it in with him to the 7-Eleven, and he's not going to leave it in plain sight in his car. So he locks it in his glove compartment, comes back out. It's in his glove compartment. He starts driving home. He gets pulled over and for speeding. Next thing he knows, he's got a concealed weapon charge. This happened all the time in the jurisdictions I worked with in Richmond area, and generally it was resolved if the guy was regular citizen, decent guy, would be give up the firearm, we'll drop the charge. And then I had this conversation with a bunch of guys. We're like, okay, there's a gun show next week. I'll buy another one. Here, let them take the $500-$600 firearm, right? That was not an issue here. When I told deputies that was going on, they kind of looked at me like I was from Mars when I first got out here, and said that ain't never happened here. But they had to take steps to stop that, so they passed that thing, the secured container law, right? At which point, on other ends of the state, they've been fighting that ever since. Does that mean it's got to be locked? No, it doesn't mean it's got to be locked. Oh, wait, does that count the middle area here in between seats? Yes, if it's closed and secured, yes. Now we get another one. Is it in a backpack? Yes, it's in a backpack that's zip closed, sitting on the floor. Secured container. No, you can't charge them with that. That's not something that'll survive. Now, but then we get to Morgan down here, and Morgan has it in a secured container, except he's drunk, and he gets charged with it. And the Court of Appeals says, no, that secured container exception doesn't apply if you're drunk. But that's their stance. So if you're drunk, just don't have a firearm even locked in a container in your car. Weapons. Use of firearm in a robbery. You must prove concealed item was a firearm or resembled a functioning firearm. Right? That's the standard. I think we all know that's the standard. It's been the standard forever, except that for a long time, we've had appellate courts in Virginia basically doing the, we think it could have been, right thing, right? Where somebody sticks their finger in the pocket and then they run away and they really haven't had time to ditch the firearm, but, we think it could have been, and they get convicted, right? And this time it just went too far. Court of Appeals says no. This apparently stuck his finger in the pocket and was wiggling around and scratching himself and doing all sorts of stuff that made it pretty clear it wasn't a firearm. So the court says, no, you gotta prove it's a firearm or something that resembled a firearm. Go back, try it again. Motor vehicles. This Katie case has worked its way through the courts in the last couple of years, and y'all haven't heard about it because we haven't had bench bar. But Katie against Commonwealth. This is where there was a motorcycle. He's in the middle of the road getting ready to make a left-hand turn. Apparently no turn lanes where he was. Basic country road like we see around here all over the place. And Katie just comes right through, plunk, right over him, runs right over him. I never saw it. And the Court of Appeals, our Court of Appeals bought that, right? I never saw him. Yeah, motorcycle. Hey, yeah, he could have missed that. Supreme Court's like, no. And then they go through and they define what recklessness is. Reckless disregard of consequences of your acts. Indifference to life, limb, and property. Like zooming down the road, not looking to make sure there's nobody, getting ready to make a left-hand turn in their motorcycle. And they say it's more than simple negligence. That's civil, right? And it's less than gross wanton or culpable negligence. That's involuntary manslaughter. And they then say the difference between the three is the likelihood of injury. Basically, the likelihood. But they don't really go any further in telling you how that works, right? So lots of words here without laying down any really strict standards. Other things. We're back to Tomlin. You'll recall this is a lady who abused or just wasn't taking care of her mother. Abuse and neglect of an adult. It has to be serious bodily injury, and they define serious bodily injury as disfigurement, fracture, severe burns, lacerations, mutilation, maiming, or life-threatening internal injuries. I'm sure that list is not exhaustive, but it's pretty close. And it is serious bodily stuff. But they say death does not need to be imminent, because Miss Tomlin's mother may have been in bad shape and been ill-treated for a few days laying there on the floor, but she wasn't anywhere near death. So you don't have to prove somebody's about to die to get convicted of abuse and neglect of an adult. Escapes. Okay, we've got two things here. First was Lopez against Commonwealth. Lopez was being taken in on a capias, and he gets away, right? Gets charged with escape, and his argument is, look, we don't have bench warrants in Virginia. We got capiases. All a capias is in order to bring you before the judge. It is not a bench warrant. It's not a warrant. It's, and only when you're under a warrant can you escape. If the officer is just bringing you in, on his own, because he's bringing you in to face the magistrate or whatever, it's not an escape. So, not a bench warrant, therefore you can't charge me with escape. And the Court of Appeals goes, yes, they can. Capias, we may use different words. Capias here, bench warrant in whatever else, place they're practicing law. Bench warrant in whatever other backwards locality, but that can't understand Latin. Bench warrant in whatever other locality can't understand Latin, but capias counts. You've escaped. And then King against Commonwealth. King decided he didn't want to be on home incarceration anymore and took off, and they charged him with escape, and he says that's not an escape. I'm not on pretrial detention or anything. I'm not in a prison. What the heck? And the Court of Appeals says, yes, it is. Go to jail. Go directly to jail. Do not pass go. Do not collect $200. And then we get to appeals. There were a number of appeal things this year. Retroactive statutes. I put this under appeals, but actually it could have been just about anywhere. It could have been under procedure as well. McCarthy against Commonwealth. Important they lay out what you have to do when the legislature changes statutes, right? Or writes a new statute or whatever. It's only retroactive if it affects procedural or remedial rights, right? And remedial rights basically are your basic, your punishment stuff, right? Punishment and restitution, all that. So, if we change, if the General Assembly changes the law today, right, on something procedural, it applies even if something's charged from 10 years ago. Procedural rights apply today, the moment they're applied. But it doesn't happen if it's substantive or vested rights. In other words, if you change the nature of the crime, the General Assembly decides that the nature of the crime has changed. For instance, changes how much you have to steal to have a felony larceny amount. Then that applies from the moment they make the change onward. It does not apply to what comes from before it, whether or not it helps or hurts the defendant. And here's the important part of it. If both substantive and procedural are affected in the same statute, it is not retroactive. It's probably too late for us to know this now, and probably was even when it came out in November 2021. But think about this on July 1, when petty larceny third, felony petty larceny third, became non-existent. Well, that both affected substantive and procedural matters, right? It affected punishment, which is procedural. It affected the actual crime, third petty larceny, substantive, and that would have meant that both of them are affected. It's not retroactive, which means that we should have kept going and convicted all your petty larceny thirds rather than all the nice deals we gave you, because we didn't know that was the way it was supposed to be. So we'll know in the future. Who knows if they ever change anything back to some of that stuff. Appeals, wrongly naming the Commonwealth. This happens all the time. And every so often, the appellate courts get upset about it. And what this is Commonwealth attorney goes in and is doing misdemeanors on Coburn Day or Norton Day, right? And some of the misdemeanors are written on, state paper. Some of them are written on town paper. Usually the ones that the town can make money off of them are written on town paper, right? Under a town ordinance. So driving suspended is under a town ordinance rather than under the county ordinance, because it's been decided that nobody gets punished for any driving suspended, even if it's their 27th time. And so it's under the town, right? Well, you know, Corey or Alicia or Jennifer are dealing with that case, and they deal with it in General District Court on the ordinance. They deal with it in Circuit Court on the ordinance. And then you appeal it after your client's been convicted of both of them, and you appeal it and you name the Commonwealth as the party who you're appealing against. Well, that's wrong. The town of Coburn is the party which you're appealing against, not the Commonwealth. And by doing that, it goes up. The Attorney General says, I haven't got any jurisdiction to deal with ordinances. I'm out. And makes a motion, objects, and motion to dismiss. And then, unless you can get somebody from the town attorney, or somebody from our office representing the town to step in to represent the town, you've lost. And that's what these three cases stand for. Now, the first two are basically if the city, town, or county makes an appearance, despite the fact that you put Commonwealth in your case, well, then they waived it. It's all good, right? They've waived the defect. Again, Johnson against Commonwealth, same thing, February this year. There was no objection to the fact that the Commonwealth was named instead of whatever town or city should have been named. And, you know, the proper party actually showed up, so it's all good, right? And then we get Lundmark, which there was no appearance. They named the Commonwealth when they should have named a town or city or county, and nobody showed up, right? The Attorney General went, not ours, not it, and then nobody from the town, city, or county shows up. The Court of Appeals says, nope, that's it, it's gone. You can't win if you don't name the right players. I mean, that is something to keep in mind if you end up doing those kind of cases. Appeals of right now are everywhere, so keep it in mind. Law of the case on appeal. Stacy against Commonwealth. If you don't challenge a ruling when it's made, no matter how wrong it is, you are stuck with it for the rest of the litigation. It is the law of the case. From the moment it hits, Circuit Court or maybe even General District Court, all the way to the Supreme Court of Virginia, that's the law of the case. If your judge in your trial, your jury trial in Circuit Court says the sky is green with yellow polka dots, and you don't object, at that point, as far as the courts are concerned, the sky is green with yellow polka dots until the moment your guy's case is done. And then the very last case we've got here, pro se help, Hammer against Commonwealth on appeals. The defendant gets to decide if there's going to be appeal. You get to decide what the appeal's about, because theoretically you understand the law better than he does, although he doesn't believe it. So your client starts filing all these things, right, pro se, to help or get things the way he wants them done. And this is the Court of Appeals saying, yeah, no, we don't have to pay attention to that. The pro se can't file their own pleadings, so they don't get to help you. They just get what you do, right? So you don't have to pay attention when they're filing those 50-page common law briefs on, the fact that there was a fringe on the flag while they're being tried, right? That's all meaningless and gone. Court of Appeals should ignore that, and you should too. Well, you should probably read it. Just make sure there's nothing in there that makes sense. But it does not apply to the case. And that, ladies and gentlemen, is the end of our CLE for today. Let's see, what do we do? 3:35. Yeah, that's within the time, I think. I think we're good.